Your daughter can't enter. Fire code violation.
I'm an ADA attorney. Neurologist filming a federal crime.
Your daughter can't enter. Fire code occupancy limits. Patricia Donovan's hands gripped my daughter's wheelchair handles at the top of the courthouse stairs, physically blocking Lily from the hearing about whether she deserved a ramp to enter her own home. I'm ADA attorney. Your neurologist is filming federal crime. When the HOA president scheduled my wheelchair-using daughter's accessibility hearing in an upstairs room with no elevator, I documented discrimination. When she physically blocked Lily from entering that hearing while claiming occupancy limits, she committed civil rights violation on camera. When she told my 12-year-old that her wheelchair was a disruption, medical experts started documenting psychological harm in real time. The board chair made 3 mistakes that day. She blocked the wrong disabled child from accessing her own hearing. She discriminated against the wrong civil rights attorney's daughter. And she forgot that physically preventing wheelchair access to accessibility proceedings creates the exact federal evidence I prosecuted for 18 years. My name is Dr. James Whitmore. I'm a disability rights attorney specializing in ADA enforcement. For nearly 2 decades, I destroyed careers of officials who violated accessibility law. The HOA president who dragged my wheelchair-bound daughter away from court just created medical testimony that federal investigators don't ignore. If you've ever watched someone deny a child basic dignity while doctors documented the cruelty, then hit the subscribe button now. Let me tell you why this matters more than HOA violations or property disputes. My wife Monica died 3 years ago, cancer. Her final words to Lily, "You deserve to access the world with dignity. Never let anyone make you feel like your needs are less important than their convenience." Lily has cerebral palsy. She's 12 years old. She uses a wheelchair full-time. Our home has 4 concrete front steps. No ramp, no handrail, nothing. Every single day since Monica died, I've carried Lily up those steps because the HOA president claims wheelchair ramps violate aesthetic standards. Patricia Donovan denied our accommodation request, cited covenant language about uniform exterior appearance, issued $6,500 in fines for unauthorized accessibility modification attempts. Then she scheduled Lily's HOA hearing to contest those fines in an upstairs conference room. No elevator, no accessible route, impossible for my daughter to attend. When I brought Lily anyway, to show the board exactly why she needs home accessibility, the board chair physically stopped us, put her hands on my daughter's wheelchair, told a disabled 12-year-old she couldn't attend her own accessibility hearing because her wheelchair violated fire code occupancy limits. She did this in front of Lily's neurologist, Dr. Sarah Chen, who was there to provide medical testimony about Lily's progressive cerebral palsy and why safe home access is medically necessary, who filmed Patricia physically preventing a wheelchair user from accessing a public hearing about wheelchair access, who documented on camera the exact moment an HOA president committed federal disability discrimination while medical professionals watched. Patricia thought she was enforcing building capacity rules. She was creating evidence of civil rights violations that I'd spent 18 years at Department of Justice prosecuting. The 4 concrete steps at our home, where I carry Lily every morning and evening, represent everything Monica fought for. My wife spent Lily's entire life advocating for our daughter's accessibility rights, at school, in public spaces, everywhere. Those steps are where Monica's promise gets tested daily, where Lily's dignity gets measured against an HOA president's obsession with curb appeal. Patricia banned the ramp, called Lily's wheelchair storage violation, fined us for medical equipment being visible from street. Then she physically blocked my daughter from a hearing about her own civil rights, in front of doctors who document trauma. Where are you watching from? Because what started with 4 concrete steps ended with medical testimony that destroyed an HOA president's career. All because she forgot that blocking wheelchair access to accessibility hearings violates exactly the federal laws I enforce professionally. Patricia Donovan thought aesthetic standards superseded my daughter's rights. Dr. Sarah Chen's testimony about the psychological harm of disability discrimination proved otherwise, and the board chair who put her hands on my daughter's wheelchair learned that medical evidence of discrimination is what federal prosecutors use to end careers. It started 8 months earlier with a certified letter denying our wheelchair ramp request for exterior modification, denied. Reason, Wheelchair ramps violate Heritage Hills architectural standards and community aesthetic uniformity. Alternative accommodation, utilize garage entrance for mobility equipment access. I read it 3 times, checked our Fair Housing Act rights, reviewed ADA reasonable accommodation requirements. Patricia Donovan had just violated federal disability law in writing. I called the HOA office that morning. Dr. Whitmore, the board chair, has determined that wheelchair ramps create visual disruption to neighborhood curb appeal. The secretary's voice was nervous, rehearsed. Mrs. Donovan suggests your daughter use the garage entrance if she requires special accommodations. Our garage has 3 steps and no space for ramp installation. And reasonable accommodations aren't special treatment. They're federal civil rights protections. Tell me in the comments, where are you watching from? Mrs. Donovan's decision is final. She's been HOA president for 8 years and understands community standards better than anyone. I filed formal appeal citing Fair Housing Act Section 804 F 3B, reasonable modifications for disabled residents. Included Lily's medical documentation from Dr. Chen, cerebral palsy diagnosis, wheelchair dependency, medical necessity of accessible home entrance. The response arrived within 48 hours. 5 new violations. Unauthorized wheelchair storage on front porch. Lily's chair, which she parks there while I carry her inside. Medical equipment visible from street, her walker, and mobility aids. Improper exterior threshold modification. The temporary rubber ramp I'd installed so Lily wouldn't trip on the door frame. Failure to maintain uniform property appearance. Subjective nonsense about how medical equipment lowers neighborhood aesthetics. Attempting to circumvent HOA architectural authority. For filing the appeal itself. Total fines, $1,500. Each violation notice included the same closing. Daily penalties of $200 will accrue until compliance achieved. That evening, Lily found me reading the violations at our kitchen table. Dad, what's wrong? Nothing, sweetheart. Just HOA paperwork. Is it about my wheelchair again? About the ramp? She was 12 years old and already understood that her disability was being treated as a violation. The HOA president thinks wheelchair ramps don't match neighborhood appearance standards, but she's wrong, and I'm going to fix it. Can't I just keep using the garage? I don't want you to get in trouble because of me. That sentence, my daughter apologizing for her medical equipment, offering to accept inferior access to avoid causing problems, broke something inside me. Monica would have been devastated. My wife spent 12 years teaching Lily that her accessibility needs were legitimate, that she deserved dignity and independence, that disability accommodations weren't favors, but rights. Now, Lily was internalizing the message that her wheelchair was a problem, that requesting basic access made her a burden. I pulled up Heritage Hills HOA records that night, started researching the board chair's history. What I found was systematic. The Martinez family, 2019, denied handrail installation for elderly father with Parkinson's, issued violations for unauthorized safety equipment. They sold within 6 months. The Thompson family, 2020, denied accessible parking space for veteran with prosthetic leg, fined for improper vehicle placement. They left within a year. The Chen family, no relation to Dr. Chen, 2021, denied visual doorbell for deaf mother, cited for unauthorized electronic modifications, gone within 8 months. Patricia Donovan had spent 8 years systematically denying every single accessibility accommodation request in Heritage Hills. Wheelchair ramps, handrails, grab bars, accessible parking, visual alert systems, audio assistance devices. Every request denied with the same justification violates aesthetic standards, or creates visual disruption, or compromises neighborhood uniformity. At least 12 families over 8 years, all with disabled family members, all denied reasonable accommodations, all eventually driven out through fines, violations, and systematic harassment. The board chair wasn't enforcing covenants. She was operating a disability discrimination campaign that violated federal civil rights law in every documented case. I compiled everything into a case file. Denial letters, medical documentation, Fair Housing Act violations, patterns of systematic discrimination. Then I did what I'd done for 18 years at DOJ. I started building a federal civil rights case, but I made one critical decision. I wouldn't file complaints until I had overwhelming evidence, until I could prove Patricia's pattern was systematic, intentional, and caused measurable harm to disabled residents. I needed medical testimony documenting psychological damage. I needed video evidence of discrimination in action. I needed the board chair to commit civil rights violations so egregious that federal investigators couldn't ignore them. Patricia Donovan thought she was protecting property values through aesthetic enforcement. She was creating the federal disability discrimination case that would end her HOA presidency and establish precedent for accessibility rights throughout North Carolina. The 4 concrete steps at my home, where I carried Lily every morning, became more than physical barriers. They became evidence in a civil rights investigation. And the board chair's refusal to allow their modification became Exhibit A in systematic disability discrimination spanning 8 years. Michael Torres appeared at my door 2 weeks after I filed the federal fair housing complaint, looking like a man who'd been wrestling with his conscience for months. Dr. Whitmore, I'm on the HOA board. I need to talk to you about Patricia and what she's been doing to families with disabilities. I recognized him. Architect. Voted with the board chair at every meeting, always silent when residents contested accessibility denials. He stood on my porch, wouldn't come inside at first, kept glancing back at his car like he might bolt any second. His hands shook as he pulled them from his pockets, then shoved them back in. He shifted his weight from foot to foot, swallowed hard before speaking. I have a niece. She's 7, spina bifida, uses a wheelchair. Okay. When I see your daughter, when I watch you carry her up those steps because Patricia won't approve a ramp, I think about my niece, about what her parents would do if someone treated her accessibility needs like violations. Why are you telling me this? Because I've been complicit. For 3 years, I've sat in board meetings and voted to deny accessibility requests because Patricia controls renovation contracts in Heritage Hills. My architectural firm depends on those projects. She's steered $200,000 in community work to my company over the past 3 years. He finally met my eyes. Last month, you filed that federal complaint. Patricia called an emergency board meeting, told us we needed to make an example of your family to discourage other residents from weaponizing disability claims against HOA authority. She said that explicitly? She said families who use federal law to undermine community standards needed to understand there would be consequences. Michael pulled out his phone, hands trembling as he navigated to his notes app. She's planning something for your upcoming hearing, something about scheduling it in a location that your daughter can't access. An inaccessible hearing location? She's scheduling it in the upstairs conference room. No elevator. She said, he paused, checked over his shoulder again. She said, if his daughter can't attend the hearing about her own accommodation request, that proves she doesn't really need home accessibility. It'll show the board she's just using her wheelchair for sympathy. Ice flooded my veins. She's deliberately creating an inaccessible hearing to prove my daughter doesn't need accessibility? She thinks it's strategic, that if Lily doesn't show up, it demonstrates the ramp request is frivolous. If you do bring her, she'll cite fire code occupancy limits to exclude her. Michael's voice dropped to barely a whisper. Patricia's been consulting with an attorney who told her HOA proceedings aren't subject to ADA Title III because they're private membership meetings, not public accommodations. That's legally wrong. HOA hearings affecting property rights are quasi-judicial proceedings subject to accessibility requirements. I know, but Patricia believes she's found a loophole. She's planning to physically prevent your daughter from attending while documenting that as proof the accommodation isn't necessary. You're telling me the HOA president is planning to commit disability discrimination on camera? I'm telling you she doesn't think it's discrimination. She thinks it's demonstrating that special treatment requests are manipulative tactics. Michael's hands clenched. Dr. Whitmore, I can't officially oppose her. My firm would lose every contract in Heritage Hills. My employees depend on that income. But I wanted you to know what's coming so you can protect your daughter. Why risk telling me at all? Because 3 years ago, my niece asked her parents for a wheelchair ramp at her school. The principal said it would disrupt building aesthetics. My sister had to fight for 6 months to get basic access for her 7-year-old daughter. His voice broke. Watching you carry Lily up those steps every day while Patricia calls her wheelchair aesthetic disruption, I can't stay silent anymore, even if it costs me everything. Can you testify about what Patricia said in that board meeting? About her plan to exclude Lily from her own hearing? Michael looked at the ground, shoulders hunched with the weight of competing loyalties. If there's legal protection, if my firm won't lose everything Patricia controls, then yes. I'll testify to her exact words about making an example of your family and proving disability claims are manipulative. I'll make sure you're protected. After he left, I understood the full scope of Patricia's strategy. She wasn't just denying accommodations. She was engineering situations designed to humiliate disabled residents while creating false justification for discrimination, scheduling accessibility hearings in inaccessible locations, then claiming the disabled person's inability to attend proved they didn't really need accommodations. The board chair thought she'd found a clever way to deny civil rights while manufacturing evidence that those rights weren't necessary. She'd actually created the perfect setup for federal disability discrimination prosecution captured on video, with medical witnesses documenting every moment. Patricia Donovan had just handed me exactly what I needed to destroy her authority. And she had no idea medical experts would be there to document the psychological harm of telling a 12-year-old her wheelchair made her too disruptive to attend her own hearing. The formal hearing notice arrived 5 days later, exactly as Michael had warned. Heritage Hills, HOA violation hearing. Dr. James Whitmore, property owner. Date, May 15th, 3 p.m. Location, Heritage Hills Community Center, 2nd floor conference room A. 2nd floor, no elevator, no accessible route. The notice included a map showing the conference room location, top of a 14-step staircase with no alternative access. I called the HOA office immediately. This hearing location isn't wheelchair accessible. My daughter Lily needs to attend, since the violations concern her accommodation request. The secretary, same nervous voice as always, put me on hold, then came back with Patricia's message. Mrs. Donovan says the conference room has been reserved for months. All other spaces are unavailable. She suggests you attend alone if mobility access is an issue. This is a hearing about whether my daughter requires a wheelchair ramp. She has the right to be present. Mrs. Donovan states that HOA proceedings are membership meetings, not public hearings. Attendance is at board discretion. If your daughter cannot access the designated location, that's unfortunate but not the HOA's responsibility. I'm documenting this as deliberate disability discrimination. Mrs. Donovan anticipated you might claim discrimination. She's prepared documentation showing the conference room location was selected based on availability, not any discriminatory intent. She'll see you at the hearing, Dr. Whitmore. 3 p.m., 2nd floor. She hung up. I sat in my office staring at that hearing notice, watching Patricia's strategy crystallize. Schedule inaccessible hearing, exclude disabled child, claim her absence proves she doesn't need accommodations, document the whole thing as objective assessment rather than discrimination. Then I made 3 calls. First, Dr. Sarah Chen, Lily's neurologist. Sarah, I need you at an HOA hearing next Tuesday. They've scheduled it in an inaccessible location, and they're planning to physically exclude Lily while claiming that proves she doesn't need home accessibility. They're scheduling a wheelchair accessibility hearing in a place wheelchairs can't reach? Deliberately, and I need medical testimony documenting the psychological harm of telling a disabled 12-year-old she's too disruptive to attend her own civil rights hearing. I'll be there. And James, I'm bringing my camera. If they physically prevent Lily from accessing that hearing, I'm documenting every second. Second call, my contact at HUD's Office of Fair Housing and Equal Opportunity. This is Dr. Whitmore. I'm filing supplemental evidence in my fair housing complaint against Heritage Hills HOA. The board president has scheduled my daughter's accessibility hearing in an intentionally inaccessible location as strategy to exclude her and claim her absence proves she doesn't need accommodations. She's created an inaccessible hearing about accessibility. That's textbook disability discrimination. I'm documenting everything. But I need federal investigators ready to move fast once I have video evidence of civil rights violations. We'll have investigators on standby. If she physically prevents your daughter from accessing that hearing, we'll have grounds for immediate intervention. Third call, Michael Torres. The hearing's scheduled. 2nd floor, no elevator. Exactly as you warned. I need you to be there as witness to whatever Patricia does. I'll be there. But Dr. Whitmore, she's been preparing the other board members, telling them your daughter's accessibility claims are manipulation and that excluding her from the hearing will expose the fraud. She genuinely believes she's protecting the HOA from being taken advantage of. She believes denying civil rights to disabled children is protective enforcement. She's convinced herself that families who request accommodations are gaming the system to get special treatment. In her mind, proving your daughter doesn't really need a ramp by excluding her from an inaccessible hearing is exposing dishonesty, not committing discrimination. That night, I explained to Lily what was going to happen. There's a hearing next week about the HOA violations. The board chair scheduled it in a place you can't access. She's going to try to prevent you from attending. Why would she do that? Because she thinks if you can't attend, it proves you don't really need a wheelchair ramp at home. Lily's face showed confusion, then hurt, then something that broke my heart. Resignation. Maybe she's right. Maybe I'm just causing problems. Maybe we should just use the garage like she said. No. I knelt beside her wheelchair. Your mother spent your entire life teaching you that accessibility isn't special treatment. It's your right. The HOA president is wrong, and what she's planning is illegal discrimination. But I need you to be brave enough to go to that hearing knowing she might try to stop us. Will you carry me up the stairs? I'll try. But the board chair might physically prevent us. And if she does, Dr. Chen will document everything. Other doctors will testify about how discrimination harms you, and federal investigators will make sure she faces consequences. This is because of Mom's promise, isn't it? About dignity and access? This is about making sure your mother's promise means something, that disabled kids don't get told their wheelchairs make them too disruptive to attend hearings about their own rights. But even as I prepared Lily for what was coming, fear gnawed at me. Patricia believed she was legally protected, that HOA authority superseded disability law, that excluding Lily would vindicate her position rather than destroy it. What if she was so convinced of her righteousness that she'd commit federal crimes on camera without realizing the evidence she was creating? The board chair was about to find out that disability discrimination captured by medical professionals doesn't justify HOA decisions. It ends careers. I spent the week before the hearing building the federal case with the precision I'd used for 18 years at Department of Justice. Documented every accessibility denial in Heritage Hills history, interviewed 12 families Patricia had driven out, compiled medical records, denial letters, violation notices showing systematic discrimination. But I also did something else, something my DOJ training had taught me about civil rights enforcement. I researched Patricia's own statements about disability accommodations. Found HOA meeting minutes from 2019 where she'd stated, "Wheelchair ramps create visual blight that diminishes property values for all residents. We must protect community investment by maintaining architectural uniformity." Found emails from 2020 where she'd written, "Families demanding special accommodations should consider whether Heritage Hills is appropriate for their situations. Communities designed for aesthetic excellence cannot accommodate every medical condition." Found a newsletter article from 2021 where she'd been quoted, "Our strict architectural standards are what make Heritage Hills desirable. Residents who require extensive modifications might be happier in communities with looser standards." Every statement revealed Patricia's belief that disability accommodations were inferior to aesthetic preferences, that accessible design lowered property values, that disabled residents should go elsewhere rather than request modifications. I compiled it into a pattern analysis, 2017 to 2024, 100% denial rate for accessibility requests, 12 families with disabled members forced out through violations and fines, 0 approved wheelchair ramps, handrails, accessible parking, or other ADA modifications, systematic documentation treating medical equipment as aesthetic violations, consistent messaging that disability accommodations compromise property values. The pattern wasn't just discrimination, it was policy. Patricia had built an entire HOA enforcement philosophy around excluding disabled residents. I also coordinated with Lily's medical team for documentation beyond Dr. Chen's neurology records. Dr. Michael Patterson, physical therapist, wrote report detailing how carrying Lily up steps daily creates injury risk, prevents independence development, and causes psychological harm by denying age-appropriate autonomy. Dr. Rebecca Morrison, occupational therapist, documented how lack of accessible home entrance forces Lily to rely on father for basic access, reinforcing helplessness rather than fostering independence skills critical for cerebral palsy patients. Dr. Jennifer Yu, child psychologist, assessed Lily and documented that being told her wheelchair is a violation and her accessibility needs are special treatment demands has caused measurable anxiety, depression, and internalized shame about her disability. Each expert's report concluded the same thing, denying Lily accessible home entrance while characterizing her medical equipment as aesthetic violations causes psychological trauma beyond the physical access barriers. I had 12 pages of medical testimony documenting harm, but I needed one more element to make the federal case overwhelming. I needed video evidence of Patricia committing discrimination while medical experts witnessed and documented the civil rights violation in real time. The inaccessible hearing she'd scheduled was about to provide exactly that. I also filed formal requests under North Carolina Public Records Act for all HOA communications regarding accessibility requests, board meeting recordings discussing my family, and documentation of Patricia's decision-making process for hearing location selection. The HOA attorney responded with heavily redacted documents and claims of deliberative process privilege. But what they did provide showed something damning. Email from Patricia to board members. Whitmore hearing scheduled second-floor conference room. If he brings wheelchair daughter to prove point, we cite occupancy limits. If she doesn't attend, we note her absence as evidence accommodation isn't truly necessary. Either outcome supports our denial. She documented her discriminatory strategy in writing, planned to use Lily's inaccessibility as proof she didn't need accessibility, created a trap where attending or not attending both supposedly justified discrimination. I forwarded that email to HUD investigators with a single note, Exhibit A, premeditated disability discrimination. The response came within hours. Dr. Whitmore, we're escalating your complaint to priority investigation. If the hearing proceeds as described and discrimination occurs with medical witnesses present, we'll have grounds for immediate federal intervention. Document everything. That Friday, 3 days before the hearing, Patricia sent one final message. Certified letter to my home address, copying all board members. Dr. Whitmore, your continued attempts to circumvent HOA architectural standards through disability claims are noted. The board has reviewed your requests and determined that alternative accommodations, garage access, are reasonable and sufficient. Your insistence on front entrance modifications demonstrates unwillingness to compromise and raises questions about whether your daughter's needs are being manipulated for personal agenda. The hearing scheduled May 15th will proceed as planned. Attendance is your choice. However, disruptions, including unauthorized individuals or recording devices, will result in hearing postponement and additional violations. The board expects professional conduct befitting a community resident, not litigation tactics befitting your former DOJ employment. Respectfully, Patricia Donovan, HOA President. That letter, claiming Lily's disability was being manipulated, that requesting basic accessibility was refusal to compromise, that my civil rights expertise was litigation tactics rather than legitimate advocacy, crystallized everything. The board chair genuinely believed disabled residents requesting accommodations were the problem, not her systemic discrimination. She thought excluding Lily from an inaccessible hearing would expose manipulation rather than commit federal crimes. She'd convinced herself that 18 years of DOJ civil rights enforcement made me biased rather than expert. Patricia Donovan had built a worldview where disability discrimination was justified as standards enforcement, and civil rights advocacy was characterized as gaming the system. That worldview was about to collide with federal law, medical testimony, and video evidence. And the collision would end her HOA presidency. The night before the hearing, I found Lily sitting at the bottom of our front steps, staring at the 4 concrete barriers that separated her from independent home access. She'd wheeled herself outside, positioned her chair at the base of the steps, and was just looking at them. Lily, what are you doing out here? Counting. There are 4 steps. I counted them every day this week. Her voice was small, distant. When Mom was alive, she'd help me up them, hold my hands, support my back, make sure I didn't fall. Now you carry me. Tomorrow, the HOA president is going to tell everyone I don't really need a ramp because I've been managing without one. That's not what tomorrow is about. Yes, it is, Dad. She scheduled the hearing somewhere I can't go. So when I can't attend, she'll say that proves I don't really need accessibility, that I'm faking how bad my disability is. Tears streamed down her face. Maybe she's right. Maybe I'm just being difficult. Maybe I should stop asking for special treatment. I knelt beside her wheelchair, felt my heart shattering. Listen to me very carefully. Your mother spent 12 years fighting for your rights, teaching you that accessibility isn't special treatment, it's basic dignity, that your disability doesn't make you less deserving of independence. But I caused so many problems. The HOA fines, the violations, people staring when you carry me. Mrs. Chen down the street won't even talk to us anymore because Patricia told her not to help that wheelchair girl. Those aren't problems you're causing. Those are civil rights violations Patricia is committing. I heard you on the phone with the federal investigators. You're building a whole case because of me, because I can't just use the garage like normal people. You are normal people. You're a 12-year-old girl who deserves to enter her own home safely and independently. The board chair is the one who's abnormal. She's systematically discriminating against disabled residents and calling it aesthetic enforcement. Lily looked up at me with eyes too old for 12, too burdened by understanding that her medical needs made her a target. Tomorrow, when she tries to stop us from coming into the hearing, what if she's mean to me? What if she says things that make me feel bad about my wheelchair? Then Dr. Chen will document every word. Other medical experts will testify about the psychological harm of disability discrimination. And federal investigators will use that evidence to make sure she never treats another disabled child the way she's treated you. This is really important to you, isn't it? Not just the ramp, but making sure Mom's promise means something. Your mother's last words were about your dignity and access. Tomorrow, we're going to honor that promise by refusing to let an HOA president tell you that your wheelchair makes you too disruptive to attend your own hearing. But even as I said it, I watched Lily internalize what was coming, the confrontation, the potential humiliation, the possibility that Patricia would physically prevent her from accessing the hearing while calling her disability problematic. Dad, I'm scared. I know, sweetheart, but sometimes being brave means doing the right thing even when you're terrified. Mom was brave every single day fighting for your rights. Tomorrow, we're being brave too. I helped Lily back into the house, carried her up those 4 steps one more time, knowing that tomorrow, medical experts would document what denying this accessibility does to a child's psyche, knowing that Patricia's plan to exclude Lily from the hearing would be captured on camera, knowing that every moment of discrimination would become evidence in federal prosecution, but also knowing that my 12-year-old daughter, who'd lost her mother 3 years ago and now faced systematic discrimination for having cerebral palsy, was being put through trauma that should never happen to any child. That night, I reviewed everything one final time, medical testimony ready, video recording equipment prepared, HUD investigators on standby, pattern documentation complete, legal framework established. Michael Torres would witness from inside the board, Dr. Chen would film from beside Lily, I would document as both father and civil rights attorney. Patricia had engineered an inaccessible hearing as strategy to justify discrimination. She'd created the perfect trap for herself. Because tomorrow, when she put her hands on my daughter's wheelchair and told a disabled child she couldn't attend her own accessibility hearing, medical professionals would document federal crimes in real time. The board chair thought she was exposing manipulation. She was committing disability discrimination that would end her HOA presidency and establish precedent for accessibility rights enforcement across North Carolina. If you've ever watched your child question whether they deserve basic dignity because authority figures treat their medical needs as violations, stay with me. Because what happened when Patricia physically blocked Lily from that hearing proved that disability discrimination documented by doctors doesn't just violate federal law, it triggers the kind of civil rights prosecution that destroys careers and transforms communities. Tomorrow, at 3 p.m., Monica's promise about dignity and access would be tested against Patricia's belief that aesthetic standards supersede disability rights. Medical testimony would determine which worldview survived. And I already knew the outcome, because I'd spent 18 years prosecuting officials who made Patricia's exact mistakes. The board chair just didn't know it yet. Michael Torres called me at 7 a.m. the morning of the hearing, voice shaking with barely controlled rage. Dr. Whitmore, I just left an emergency board meeting Patricia called at 6 this morning. You need to know what she's planning. I'm listening. She's not just scheduling an inaccessible hearing. She's planned a coordinated strategy to exclude Lily and document it as objective process. I heard paper rustling. She distributed talking points to all board members. I photographed them before leaving. Send them to me. Now. Seconds later, my phone displayed Patricia's strategy document. Whitmore Hearing Protocol, Conference Room. A maintains fire code occupancy limit of 12 persons. If Dr. Whitmore attempts entry with wheelchair using daughter, cite safety violations and occupancy restrictions. Offer alternative. Dr. Whitmore may attend alone or request rescheduling for accessible location, delaying resolution 60+ days. If he insists on daughter's attendance, note his willingness to violate safety codes and disrupt proceedings. If daughter does not attend, document absence as evidence accommodation request lacks medical necessity. Remain professional. Frame all decisions as safety and procedural compliance, not disability discrimination. Expect recording devices. All statements must emphasize safety and procedure, not daughter's disability. The document was signed by Patricia and dated 3 days earlier. She'd pre-planned every aspect of discriminating against my daughter while creating documentation to make it appear procedurally justified. Michael, this is premeditated disability discrimination documented in writing. It gets worse. His voice dropped to whisper. After distributing those talking points, Patricia said something the others don't know I recorded. He played audio from his phone. Patricia's voice, clear and unmistakable. The Whitmore situation is a test case. If we can successfully deny this accommodation using procedural justifications, it establishes precedent for denying future disability claims. Other HOAs are watching how we handle families that weaponize federal law against community standards. We demonstrate that aesthetic uniformity legally supersedes individual accommodation demands. The daughter's attendance is irrelevant. We've already determined the ramp request will be denied regardless of today's outcome. The recording continued with Patricia explaining her legal theory, that HOA covenants, as private contracts, allow communities to prioritize architectural uniformity over subjective accessibility preferences, and that families with extensive medical needs should self-select into appropriate communities, rather than force modifications onto existing neighborhoods. She genuinely believes she's establishing legal precedent, Michael said, that denying your daughter's accommodation will help other HOAs resist what she calls disability accommodation overreach. She thinks she's protecting property rights, not violating civil rights. You recorded her admitting the hearing outcome is predetermined, that Lily's attendance is irrelevant because they've already decided to deny accommodations regardless of evidence. She said it to 5 board members. I have it all on audio. But Dr. Whitmore, Michael's voice cracked. I can't release this publicly without losing everything. My firm, my contracts, my employees' livelihoods. Patricia controls too much business in Heritage Hills. Can you testify under oath if there's legal protection? If I'm guaranteed immunity from Patricia's retaliation, if my business relationships are protected through legal means, then yes, I'll testify to everything. The predetermined outcome, the discriminatory strategy, her explicit statements about establishing anti-accommodation precedent. I'll make sure you're protected, but I need you at that hearing today as witness to whatever Patricia does. I'll be there. Just know that she's not planning to physically drag your daughter. She's planning to make it impossible for Lily to enter while claiming fire code and safety compliance. Then she'll use Lily's exclusion as proof the accommodation isn't necessary. After hanging up, I reviewed what Michael had provided. Written strategy document showing premeditated discrimination. Audio recording of Patricia admitting predetermined outcome. Explicit statements about establishing precedent for denying disability accommodations. Testimony from conflicted insider willing to expose the conspiracy. I forwarded everything to HOA investigators with a note. Exhibit B, premeditated civil rights conspiracy with predetermined discriminatory outcome. Their response was immediate. Dr. Whitmore, this is federal disability discrimination conspiracy. We're coordinating with DOJ Civil Rights Division. Proceed with the hearing as planned. Document everything that happens. We'll have investigators ready for immediate intervention based on what occurs today. I also sent copies to Dr. Chen with instructions. Film everything. Patricia is planning coordinated discrimination while claiming safety compliance. Medical documentation of Lily's reaction to being excluded will be critical evidence. That afternoon, I dressed Lily in her favorite outfit. Purple dress, butterfly clips in her hair, the outfit Monica had bought her for last year's school awards ceremony. Why am I dressing up if they're not going to let me in? Lily asked. Because you're attending your own hearing regardless of what the board chair planned. Because you deserve dignity and presence. Because your mother would want you to show up and demand the rights you've earned. What if it's really bad, Dad? What if she says mean things? Then medical experts document every word. Federal investigators use it as evidence. and you learn that standing up for your rights, even when authority figures try to humiliate you, is exactly what Mom taught us to do. We drove to Heritage Hills Community Center at 2:45 p.m. Dr. Chen was already there, phone camera ready, professional demeanor masking the fury I knew she felt about Patricia's discrimination. Michael Torres stood near the entrance, face pale, hands shaking, clearly terrified of what supporting us might cost him professionally. At 2:58 p.m., we approached the building entrance. The board chair was waiting at the bottom of the staircase leading to the second-floor conference room, clipboard in hand, 2 other board members flanking her. Patricia's face showed smug confidence, the expression of someone who believed she'd engineered an airtight justification for discrimination. She had no idea she was about to commit federal crimes while medical professionals documented psychological harm in real time, and she definitely didn't know Michael Torres was recording audio of everything she said. The board chair was about to learn that premeditated disability discrimination documented by insider witnesses doesn't establish legal precedent. It triggers federal prosecution. I spent the 2 hours before the confrontation coordinating federal response with the precision I'd learned prosecuting civil rights cases at DOJ. Called my former supervisor at Civil Rights Division. I'm documenting HOA president committing premeditated disability discrimination against my daughter. Need federal investigators ready to move immediately after evidence is captured. James, you're the complainant and the victim. You can't be the investigating attorney. I know. But I can document federal crimes as they occur and provide evidence to prosecutors. HOA president has predetermined denial outcome, scheduled inaccessible hearing, and planned strategy to exclude my wheelchair-using daughter while claiming safety compliance. It's systematic discrimination with written documentation. Send everything you have. We'll have investigators on standby. If discrimination occurs with medical witnesses present as you've described, we'll coordinate immediate federal intervention. I transmitted Michael's recordings, Patricia's strategy document, the pattern analysis of 12 denied families, medical expert reports documenting psychological harm. Then, I coordinated with disability rights advocacy organizations, Americans with Disabilities Act National Network, Disability Rights, North Carolina, National Fair Housing Alliance, provided each organization with background, systematic accessibility denials over 8 years, predetermined hearing outcome, inaccessible hearing location as discrimination strategy, HOA president statements about establishing precedent for denying accommodations. If what you're describing happens, if she physically excludes a wheelchair-using child from her own accessibility hearing while medical experts document it, that's the kind of test case we've been waiting for, the DRAN attorney told me. Clear discrimination, sympathetic victim, premeditated strategy documented in writing, medical testimony about psychological harm. This could establish precedent forcing HOAs to comply with federal disability law. I also prepared media contacts, local disability rights reporters, investigative journalists covering civil rights, national news organizations interested in accessibility discrimination. Didn't send anything yet, but had everything ready to distribute the moment Patricia committed discrimination on camera. The strategy was clear. Document federal crimes as they occur. Capture medical expert testimony about psychological harm in real time. Provide evidence immediately to federal investigators. Release to media and advocacy organizations simultaneously. Create overwhelming pressure from legal, medical, and public exposure angles. Patricia thought she was executing a procedural strategy to deny accommodations. She was walking into coordinated federal civil rights prosecution, backed by medical evidence and national advocacy organizations. But I also prepared something else, the legal framework that would destroy Patricia's entire justification. Researched federal case law on HOA accessibility obligations, United States versus Tropic Seas, Inc., see 2008. HOAs must provide reasonable accommodations under Fair Housing Act, Shapiro versus Cadman Towers, 2003. Wheelchair ramps are reasonable modifications that HOAs cannot deny based on aesthetic preferences. Hollis versus Chestnut Bend Homeowners, 2011. HOA meetings affecting property rights are quasi-public proceedings subject to ADA accessibility requirements. Every case Patricia would need to justify her discrimination had been decided against HOA authority and in favor of disability rights. I compiled the case law into a brief, ready to file with federal court the moment Patricia committed the discrimination I knew was coming. I also prepared something for Lily, a letter from her mother that Monica had written during her final weeks, meant to be read when Lily faced her first major fight for accessibility rights. My dearest Lily, if you're reading this, it means you've encountered someone who treats your wheelchair as a problem instead of recognizing you as a person deserving dignity and access. I want you to know, your disability doesn't make you less. Your accessibility needs aren't burdens or special treatment. They're civil rights that people fought and died to establish. When someone tells you that curb appeal matters more than your ability to enter a building safely, they're wrong. When someone says aesthetic standards supersede your accommodation requests, they're violating federal law. When someone makes you feel like your wheelchair is disruptive or your needs are excessive, they're discriminating against you. Your father knows how to fight these battles. He spent his career protecting people like you from people who think disability rights are negotiable. Trust him, trust yourself, and remember, every accessibility ramp, every accommodation, every fight for dignity isn't just about you. It's about every disabled person who comes after you. Be brave. Stand up for your rights. Make them see you. I love you always, Mom. I gave Lily the letter that morning, watched her read it through tears, saw her spine straighten with determination inherited from Monica. Mom knew this would happen, that people would treat my wheelchair like a violation. Your mother knew that disability rights are fought for constantly, that each generation has to defend accommodations from people who think aesthetics or convenience matter more than access. I'm ready, Dad. Let's go show the HOA president that Mom's promise about dignity wasn't just words. At 2:45 p.m., we drove to Heritage Hills Community Center. Federal investigators on standby. Medical experts prepared to document psychological harm. Advocacy organizations ready to amplify the case nationally. Media contacts prepared to expose discrimination. Legal framework established to destroy Patricia's justifications. And one 12-year-old girl carrying her dead mother's letter about standing up for disability rights. About to face an HOA president who'd spent 8 years denying accessibility to protect property values. The board chair had engineered an inaccessible hearing to justify discrimination. She'd engineered her own federal prosecution. And she had 15 minutes before everything she'd built collapsed under the weight of civil rights law, medical testimony, and a father who'd spent 18 years destroying officials who made her exact mistakes. Patricia thought she understood the law. She was about to discover that premeditated disability discrimination documented by medical experts and insider witnesses doesn't establish precedent. It triggers the kind of federal prosecution that ends careers and transforms enforcement of accessibility rights. At 2:58 p.m., we approached the Heritage Hills Community Center entrance. Patricia stood at the base of the 14-step staircase leading to the second-floor conference room, clipboard in hand, flanked by 2 board members who looked uncomfortable with whatever they'd been instructed to do. Dr. Chen positioned herself 3 steps behind us, phone camera already recording, professional observer documenting what was about to unfold. Michael Torres stood near the building entrance, phone concealed but audio recording active, face pale with the knowledge of what Patricia had planned. I pushed Lily's wheelchair toward the stairs, knowing exactly what would happen next. The board chair stepped forward, blocking our path. Dr. Whitmore, the hearing is scheduled for Conference Room A on the second floor. I'm afraid wheelchair access isn't available for that location. Then we'll need the hearing relocated to an accessible space. My daughter has the right to attend. All other conference rooms are reserved. We can reschedule for next month if accessibility is required, though that will delay resolution of your violations and increase accruing fines. Or you can hold the hearing in the first-floor community room right now and comply with federal accessibility law. Patricia's expression hardened. The hearing will proceed as scheduled at 3 p.m. in Conference Room A. You may attend alone, or we can reschedule. Those are your options. Under the Americans with Disabilities Act and Fair Housing Act, you're required to provide reasonable accommodations for disabled participants in hearings affecting their property rights. Refusing to relocate to an accessible space is disability discrimination. Dr. Whitmore, HOA proceedings are private membership meetings, not public accommodations. We're not subject to ADA Title III requirements. The conference room was reserved months in advance based on availability, not any discriminatory intent. Dr. Chen moved closer, camera capturing every word. Mrs. Donovan, I'm Dr. Sarah Chen, Lily's neurologist. This hearing directly concerns my patient's medical need for home accessibility. She has the right to be present for proceedings about her civil rights. Doctor, I appreciate your concern, but this is an HOA administrative matter. Medical opinions about accommodation necessity will be considered by the board, but attendance isn't required for us to review documentation. You're telling a 12-year-old with cerebral palsy that she can't attend her own accessibility hearing because you scheduled it somewhere her wheelchair can't go? I'm explaining that our conference room has occupancy limits and no elevator access. If that creates inconvenience, we can reschedule. I looked at Patricia, at her absolute conviction that what she was doing was procedurally justified rather than discriminatory. You're intentionally excluding my disabled daughter from a hearing about her disability accommodations. You understand that's textbook federal civil rights violation? I'm following Fire Code occupancy restrictions and HOA procedural requirements. If your daughter cannot access the designated hearing location, that's unfortunate, but not discriminatory. Patricia checked her watch. It's now 3:01 p.m. The hearing begins in Conference Room A immediately. You may attend or forfeit your opportunity to contest the violations. She turned toward the stairs. I made the decision I'd been preparing for. I'm bringing Lily upstairs. She will attend her own hearing. Patricia turned back, and I saw the trap spring exactly as Michael had warned. Dr. Whitmore, Conference Room A has a 12-person occupancy limit per Fire Code. Current attendance is 10 board members and advisors. Adding you exceeds capacity. Adding your daughter and her wheelchair creates safety violations and blocks emergency egress routes. So, your position is that my daughter's wheelchair makes her a fire hazard? My position is that we must comply with fire safety regulations. If wheelchair accommodation creates occupancy issues, alternative arrangements are necessary. The alternative arrangement is relocating to an accessible space, which isn't available today. So you may attend alone, or we reschedule and your violations continue accruing daily fines during the delay. Lily had been silent through the entire exchange, but now she spoke, voice shaking but clear. I'd like to attend my hearing, please. It's about whether I can have a ramp at my house so I don't have to be carried every day. Patricia looked down at Lily with an expression I'd seen before in discrimination cases, discomfort mixed with determination to maintain position despite obvious cruelty. Sweetheart, this isn't personal. It's about following proper procedures and safety codes. Your father can represent your interests without you being physically present. But it's about me, about my wheelchair. Shouldn't I be there? The board can make appropriate decisions based on documentation without... You're telling my daughter she can't attend a hearing about her own civil rights? I kept my voice level, clinical. And you're claiming Fire Code justification? I'm explaining occupancy limitations and offering alternatives. Patricia's tone remained professionally dismissive. Now it's 3:03. The hearing proceeds with or without you. She turned and started up the stairs. I looked at Dr. Chen, who was filming everything. At Michael Torres, who was recording audio. At Lily, sitting in her wheelchair at the bottom of stairs that symbolized everything Monica had fought against. Lily, I'm going to try to bring you upstairs. Whatever happens, remember Mom's letter. Remember you deserve dignity and access. I moved to lift my daughter from her wheelchair. Patricia's voice cut through from halfway up the stairs. Dr. Whitmore, bringing unauthorized attendees who violate occupancy limits will result in hearing cancellation and additional violations for disrupting HOA proceedings. That's when I understood the full scope of her strategy. If we stayed at the bottom, she'd claim Lily's absence proved accommodations weren't necessary. If we attempted to bring Lily up, she'd claim we violated safety codes and disrupted proceedings. Either outcome justified denying accommodations while creating documentation that made discrimination appear procedural. The board chair had engineered a perfect trap. She'd just committed it on camera with medical witnesses documenting every discriminatory statement. And she had no idea federal investigators were watching this evidence accumulate in real time. I lifted Lily from her wheelchair, felt her arms wrap around my neck the way they had thousands of times over the past 3 years, and started carrying her up the stairs. Patricia appeared at the top landing, physically blocking the doorway to Conference Room A. Dr. Whitmore, stop. You're violating Fire Code occupancy limits and disrupting scheduled proceedings. I'm bringing my daughter to her own hearing. Step aside. I cannot allow unauthorized attendees who create safety violations. The conference room is at capacity. I reached the top step, Lily in my arms, Dr. Chen filming from below, and Patricia's hands moved to grip my daughter's wheelchair handles, still at the bottom of the stairs. This medical equipment creates egress obstruction. It cannot be brought into the hearing space. That's my daughter's wheelchair. She needs it. She can participate from your arms. The wheelchair remains here. Dr. Chen's voice carried up the stairwell, professional and devastating. Mrs. Donovan, you're telling a 12-year-old cerebral palsy patient that she must be carried by her father while her wheelchair, her mobility device, is confiscated as a safety violation? I'm enforcing fire code and occupancy regulations. If accommodation equipment creates compliance issues, modifications are necessary. Then Patricia did something that captured her entire worldview on camera. She physically pulled Lily's wheelchair away from the stairs, moved it to the side hallway, and said, "The hearing will proceed now. Dr. Whitmore may enter with his daughter if he carries her. Medical equipment remains outside." Michael Torres emerged from the conference room behind Patricia, phone openly recording now, no longer concealing his documentation. "Patricia, this is disability discrimination. You're excluding a child's wheelchair from her own accessibility hearing." The board chair's face flushed with anger at his betrayal. "Michael, return to your seat. This is procedural enforcement, not discrimination. You scheduled an inaccessible hearing, claimed occupancy limits, and just confiscated a disabled child's mobility device. This is exactly what disability discrimination looks like." Patricia's composure cracked. "This board has architectural standards to maintain. We cannot allow every family with medical situations to demand modifications that compromise community aesthetics. This hearing will determine if accommodations are truly necessary or simply requested for convenience." By excluding the person who needs accommodations from attending, Michael's voice shook with suppressed rage. By treating her wheelchair as a violation, Dr. Chen had moved up the stairs, camera capturing everything from 3 feet away. "Mrs. Donovan, I need to document something for medical records. Lily, how do you feel right now being carried by your father while the HOA president confiscated your wheelchair and told you it's a safety violation?" Lily's voice was tiny, broken. "I feel like I'm bad, like my wheelchair is a problem, like I'm causing trouble by being here. And how often do you feel this way?" "Every day when Dad carries me up our front steps because Mrs. Donovan won't let us have a ramp. Every time someone sees my wheelchair and looks uncomfortable. Every time the HOA sends papers saying my medical equipment violates appearance standards." Dr. Chen turned the camera directly on Patricia. "Do you understand that denying a disabled child access to her own civil rights hearing while confiscating her mobility device causes measurable psychological trauma? That telling her wheelchair is a safety violation and her presence is disruptive reinforces internalized shame about disability?" Patricia's response was captured in perfect clarity. "Doctor, I appreciate medical perspectives, but this board must balance individual accommodation requests against community standards that benefit all residents. We cannot compromise property values and aesthetic uniformity for every medical situation. If this family's needs are extensive, perhaps a community with different standards would be more appropriate." The words hung in the air. The explicit statement that disabled residents should go elsewhere rather than request accommodations, that property values superseded civil rights, that extensive medical needs made families inappropriate for Heritage Hills. Michael's recording captured it. Dr. Chen's video documented it. And I stood there holding my 12-year-old daughter, who'd just been told her wheelchair was a safety violation and her presence was disruptive to a hearing about her own accessibility rights, knowing that Patricia had just destroyed her HOA presidency on camera. "Mrs. Donovan," I said quietly, "you've just committed federal disability discrimination, while medical experts documented psychological harm to a minor child. You've created video evidence of civil rights violations that will end your authority and establish legal precedent for HOA accessibility enforcement. And you've done it all while claiming aesthetic standards justify excluding disabled children from their own hearings." Patricia's face showed the first flicker of uncertainty. "I've followed proper procedures and fire safety regulations. My attorney advised that HOA architectural standards—" "Your attorney is wrong. And in approximately 48 hours, federal investigators will explain exactly how wrong while serving you with civil rights violation findings." The board chair's confidence finally cracked because she'd just realized that 12-person occupancy limits, fire code claims, and procedural justifications don't protect officials who confiscate disabled children's wheelchairs while calling them safety violations. They create the evidence that destroys careers. The emergency HOA meeting was called 72 hours later after federal investigators arrived at Patricia's home with civil rights violation findings. The community center was packed. Every household in Heritage Hills wanted answers about how their HOA president had created a federal disability discrimination case that was now national news. Disability rights advocacy groups filled the back rows, media cameras lined the walls. HUD investigators sat in the front row with DOJ Civil Rights Division attorneys. HOA president excludes wheelchair. Using child from accessibility hearing confiscates mobility device. The video had gone viral within hours. Dr. Chen's footage of Patricia pulling Lily's wheelchair away while claiming it was a safety violation had been viewed millions of times. Disability rights organizations used it as definitive example of HOA discrimination. Legal experts analyzed it as textbook civil rights violation. Parents across the country shared it with rage about adults who treat disabled children's medical equipment as problems. I sat with Lily in the front row, her wheelchair prominently placed, no one questioning its presence now. The interim board chair, elected emergency after Patricia's forced resignation, opened with visible emotion. Most of you have seen the video. Most of you know that Patricia Donovan's actions have triggered federal investigation, potential civil rights prosecution, and national scrutiny of Heritage Hills. What you may not know is the full scope of what she was doing to this community. She pulled up documentation showing the 12 families over 8 years, every denied accessibility request, every family driven out through violations and harassment, every statement Patricia had made about disability accommodations compromising property values. Federal investigators have classified this as systematic disability discrimination spanning Patricia's entire presidency. She didn't deny one ramp request. She denied every accessibility accommodation for 8 years, while explicitly stating that disabled residents should self-select into appropriate communities rather than request modifications. Mrs. Martinez stood, the elderly mother whose husband with Parkinson's had been denied handrail installation. We left Heritage Hills 3 years ago because Patricia issued 47 violations after we requested safety equipment. She told us our husband's disability was lowering community standards. We sold our home at a loss and spent 3 years rebuilding our lives. Patricia Donovan destroyed my family because we asked for handrails to prevent my husband from falling. Mr. Thompson stood next, the veteran whose prosthetic leg accommodation was denied. She told me veterans with disabilities should consider communities designed for medical populations instead of expecting Heritage Hills to accommodate every situation. I lost my leg serving this country. She treated my accessibility needs like aesthetic problems. Then the federal investigator stood, voice carrying authority that silenced the room. HUD Office of Fair Housing and Equal Opportunity has completed preliminary investigation into Heritage Hills HOA's accessibility denial practices. Our findings: systematic violation of Fair Housing Act spanning 8 years, affecting minimum 12 families with documented disabilities. Pattern of denying all accessibility requests using aesthetic justifications that violate federal law. Retaliation against residents who contested denials through violations and fines. And most recently, deliberate exclusion of wheelchair using minor child from hearing about her own civil rights while confiscating her mobility device and claiming it violated safety codes. She displayed Patricia's strategy document, the smoking gun Michael had photographed. This document shows premeditated discrimination. Mrs. Donovan planned to exclude the disabled child regardless of how the hearing proceeded, then use that exclusion as justification for denying accommodations. She documented her discriminatory intent in writing 3 days before committing the violations. Then Dr. Chen provided medical testimony that devastated Patricia's remaining support. I've treated Lily Whitmore for cerebral palsy for 8 years. I've documented how denying her accessible home entrance while characterizing her wheelchair as aesthetic violation has caused measurable anxiety, depression, and internalized shame. 12-year-old patients should never feel their mobility devices are problems or their accessibility needs are burdensome. Mrs. Donovan's actions, particularly confiscating Lily's wheelchair while claiming it violated occupancy limits, constitute psychological trauma requiring ongoing therapy. She pulled up diagnostic assessments, therapy notes, medical evidence of harm. Lily developed symptoms consistent with disability-related anxiety disorder directly caused by HOA discrimination, being told repeatedly that her medical equipment violates community standards, that her accommodation requests are excessive, that her presence at her own hearing is disruptive. This causes clinical trauma. Mrs. Donovan didn't just violate federal law, she inflicted measurable psychological harm on a disabled child. The room sat in stunned silence. Then Michael Torres stood, no longer conflicted, no longer afraid. I've been on this board for 3 years. I voted to deny every accessibility request because Patricia controlled renovation contracts my firm depended on. I watched her systematically exclude disabled residents while telling myself it was about aesthetic standards, not discrimination. I was complicit through silence because I prioritized business relationships over civil rights. His voice broke. I have a niece with spina bifida, 7 years old, uses a wheelchair. When I watched Dr. Whitmore carry Lily up those stairs while Patricia confiscated her wheelchair and called it a safety violation, I saw my niece. I saw what happens when adults prioritize curb appeal over children's dignity. He held up his phone with the audio recordings. I documented Patricia's statements about establishing precedent for denying accommodations, about how excluding Lily would help other HOAs resist disability accommodation overreach. She genuinely believed she was protecting property rights by excluding disabled residents. She was committing federal crimes. The vote was called within minutes, unanimous removal of remaining board members who'd supported Patricia's discrimination, immediate approval of all denied accessibility requests from the past 8 years, formal apology to affected families, implementation of federal accessibility compliance training, appointment of HUD monitor to oversee accommodation requests. Patricia wasn't present, facing federal civil rights prosecution and civil lawsuits from 12 families. After the meeting, the 8 families who'd been driven out approached me. We're filing civil rights lawsuits now that federal investigation has documented the pattern. Can we use the medical testimony and video evidence? Yes. Federal findings and Dr. Chen's documentation will support every case. I walked out with Lily, watching Heritage Hills transform from a community that treated disability as violation into one committed to accessibility and inclusion. The board chair who'd thought aesthetic standards justified excluding disabled children was facing federal prosecution, and my daughter finally had approval for the wheelchair ramp Monica had promised her. 6 weeks later, I stood beside the newly installed wheelchair ramp at our front entrance, watching Lily wheel herself into our home independently for the first time in 3 years. No carrying, no steps, no daily reminder that her accessibility needs were considered violations. Just my daughter entering her own home with the dignity Monica had promised she deserved. The ramp was beautiful, professionally designed, ADA compliant, integrated seamlessly with our home's architecture, proof that accessibility and aesthetics weren't mutually exclusive, that disability accommodations enhanced communities rather than diminished them. Patricia Donovan faced Federal Fair Housing Act violations and civil rights prosecution. HUD consent decree required her permanent removal from HOA leadership, payment of damages to affected families, and federal monitoring to prevent future discrimination. She'd also been named in 12 civil lawsuits from families she'd systematically excluded over 8 years, each case strengthened by federal findings, medical testimony, and video evidence of her confiscating a disabled child's wheelchair. The board chair, who'd built an entire presidency on aesthetic enforcement, learned that property values don't supersede civil rights. Heritage Hills underwent complete transformation. New leadership prioritized accessibility and inclusion, approved every pending accommodation request, implemented policies protecting disabled residents from discrimination disguised as standards enforcement. Most importantly, 4 other families with disabled children moved into Heritage Hills after seeing the federal accessibility compliance, knowing their children would be welcomed rather than treated as aesthetic problems. But the real victory was simpler. Lily wheeled herself up the ramp, turned at the top, and looked back at the 4 concrete steps that had represented 3 years of daily indignity. I did it myself, Dad. Just like Mom said I should be able to. Your mother would be so proud, not just of the ramp, but of how you stood up for your rights even when the HOA president tried to humiliate you. Dr. Chen said I helped other disabled kids by being brave enough to go to that hearing. that the video of Mrs. Donovan taking my wheelchair made people understand what disability discrimination looks like. You did help them. Every accessibility ramp installed because Patricia's discrimination got exposed nationally. Those exist because you refuse to accept being treated as a violation. Lily looked at Monica's letter, now framed on the wall beside the ramp. Mom knew I'd have to fight for access. She knew people would treat my wheelchair as a problem instead of seeing me as a person, but she also knew Dad would help me fight. We fought together, sweetheart. You, me, Dr. Chen, Michael Torres, all the families Patricia excluded. We proved that disability rights aren't negotiable, that aesthetic preferences don't justify discrimination, and that HOA authority doesn't supersede federal civil rights law. The ramp represented more than physical access. It represented Monica's promise fulfilled, federal law enforced, disability rights protected, and a community transformed from one that excluded disabled residents to one that welcomed them. I thought about the hearing, Patricia physically confiscating Lily's wheelchair while claiming it violated occupancy limits, Dr. Chen documenting psychological trauma, medical experts testifying about harm caused by treating disability as an aesthetic problem. That confrontation had been captured, analyzed, shared millions of times. It became the definitive example of HOA disability discrimination. Law schools used it to teach Fair Housing Act enforcement. Disability rights organizations used it to demonstrate systematic exclusion. Medical professionals used it to show psychological impact of discrimination on children. And HOAs across the country reformed their accessibility policies because they saw what happened when aesthetic obsession violated federal civil rights law. Patricia's attempt to establish precedent for denying accommodations had backfired completely. She'd established precedent for federal prosecution of HOA officials who discriminate against disabled residents while claiming procedural justification. The 4 concrete steps at our entrance remained, preserved as reminder of what Lily had overcome, what Monica had fought for, what disability rights advocacy requires. But now they had a ramp beside them. Physical proof that access and dignity matter more than curb appeal, that disabled children deserve to enter their homes independently, that wheelchairs aren't violations or safety hazards or aesthetic problems. They're medical devices that enable people to live with dignity and independence, exactly as federal law protects and Monica promised. Lily wheeled herself into the house, and I heard her call out, "Mom, I used the ramp today, just like you said I would, just like you promised." Monica couldn't hear her, but the promise had been kept anyway, through federal law, medical testimony, civil rights prosecution, community transformation, and a father who'd spent 18 years learning exactly how to destroy officials who discriminated against disabled citizens. If you want more stories about standing up to HOA tyranny that violates civil rights, hit subscribe right now, share your story in the comments about fighting for disability accommodations or accessibility rights, and let me know where you're watching from. Because sometimes the greatest victories come from refusing to let authority figures treat your child's medical equipment as violations, and having the legal expertise to prosecute the discrimination they commit while claiming aesthetic justification. Patricia confiscated my daughter's wheelchair and called it a safety violation. Federal investigators called it civil rights conspiracy. Medical experts called it psychological trauma. And the disability rights community called it the case that finally forced HOAs to recognize that accessibility law isn't optional. The ramp is installed, the steps remain as testimony, and Lily enters her home with the dignity her mother promised and federal law guarantees, surrounded by a community that finally understands disability accommodations aren't special treatment. They're civil rights that no HOA president's aesthetic preferences can override.